Thank you for joining us today for our Succession and Estate Planning webinar. My name is Natalie Collins, and I am the Manager of Member Relations for the California Association of Winegrape Growers, and today I'll act as your moderator on this call. We've been getting a lot of questions recently about succession and estate planning, so we thought we would host this webinar to kind of address some of those issues. After today's webinar, we believe you'll have a better understanding of the importance of establishing a plan for the future. COG has a great working relationship with Pan American Insurance, which is a division of Ascension Benefits and Insurance Solutions, so we thought there would be no better company to partner with to present this information. Presenting on the topics today will be Michael Weintraub, who is the President of the Retirement Division at Ascension Benefits. Mr. Weintraub specializes in providing tax savings for individuals and businesses by using tax-qualified retirement plans. Also presenting today is Agnieszka Adams, an associate at Roisman Henel LLP, which is located here in Oakland. Mrs. Agnieszka is certified by the California State Bar Board of Legal Specialization as a specialist in estate planning, trust, and probate law. So thank you guys both for joining us today. Now real quick, we're going to go over the format of today's presentation before diving in. We will do a 45 to 50-minute presentation, and we'll open it up for question and answers after that. We will not be stopping during the presentation to take questions. However, if you have questions, please feel free to type them in the question bar, and we will answer those at the end. Recording of this webinar will also be available after the call, along with additional handouts that will be helpful and we'll be able to answer any other questions. And also, as a reminder, if you guys do have additional questions after the webinar, we do encourage you to reach out to Mike or Agnieszka and ask the questions to them. So without further delay, we're going to turn the webinar over to Agnieszka.
Good morning, everyone. I'm Agnieszka.
Right.
We apologize. I think we had a little bit of technical difficulties here, so I'll repeat. I think you weren't able to hear me after we got disconnected. So I'll start back from the beginning. So the first thing I wanted to talk about are your basic components of an estate plan. And the major documents that compose of an estate plan are your revocable trust, your pour-over will, a durable power of attorney for financial management, and another power of attorney that is called the Advanced Healthcare Directive, which is a document that gives an agent certain powers with respect to your healthcare. So the revocable trust is really going to be the primary document that will have terms about what should happen to your assets on death. And so it's not typically it's not going to be your will, it's going to be the revocable trust where we'll incorporate all of your testamentary wishes. And the revocable trust is a document that you establish during your lifetime during your lifetime, you'll serve both as the trustee of your trust, and then also you'll be the beneficiary of the trust. And then you'll be able to name a successor trustee, so that's someone other than you who'll be able to manage the assets in the trust, both on death or on incapacity. The pour-over will, is a component of your estate plan that is a backup to the trust for certain matters. So the revocable trust, you establish it during your lifetime, you transfer assets to the trust during your lifetime, but sometimes we do have situations where we might have certain assets that were just, for some reason, didn't make it to the trust during your lifetime, or maybe those are assets that for some reason couldn't be transferred to your trust. So in order for all of the dispositive provisions that you've put in to the trust to apply to all of your assets, what we have now is we have this pour-over will. It's a very simple document. All it says is if you have something in your individual name, so that would be an asset that's not titled in your name as trustee of your trust, the will directs it to be added to your trust. So it's a really nice technique because we don't have to repeat the terms again of what should happen to your assets on death in the will. We just say, just please add it to my trust. That way we know that whatever we've put in the trust will control both assets that are in the trust and then assets that are outside of the trust that the will could add to the trust later. So the pour-over will is still a component, although it's a fairly minor document. Now, the two other documents that are a part of your basic estate plan are two different kinds of powers of attorney. The durable power of attorney for financial management is a backup to the trust for incapacity. The same way as the will acts as a backup to the trust for planning on death, the durable power of attorney for financial management is a backup to the trust for incapacity. And again, if you become incapacitated, the successor trustee of your trust steps in to manage the assets for your benefit as long as you're alive. But we might have certain assets that for some reason are not part of the trust. And that's why we need an agent under the power of attorney to be able to do some of these things that the trustee can't do if you're incapacitated. And then the last document, although not least, in fact, a lot of my clients consider the Advanced Healthcare Directive as one of the most important documents in your estate plan, is a power of attorney for healthcare. And the Advanced Healthcare Directive is a little bit more limited in scope. It only allows an agent to make healthcare decisions for you if you no longer can communicate them to the health providers. And the healthcare directive is also useful because you can designate your the disposition of remains. You can put provisions about donation of organs, and then you can also make clear your wishes about life support or maybe any other medical treatment that you would want to receive. If you're unable to communicate those wishes with health providers. Okay, so let's really talk about what it means to have a revocable trust established during your lifetime. A lot of my clients will say, well, if I establish this revocable trust, am I going to still be able to have the same control over the assets that I have if I have these assets in my individual name? So the beauty of the revocable trust is that it's really just a legal fiction. You create this trust during your lifetime, you transfer assets to it currently, but because you have this very powerful right to change the terms, revoke the trust, that's why it's called a revocable trust, the trust is essentially disregarded for any purpose. And that's because you have this power to essentially do whatever you want with this trust, change the terms, amend it, completely revoke it. Everybody thinks the trust is still you because you've reserved this very powerful right. In terms of managing, for my married clients, sometimes they ask, well, what if I own assets with my spouse, but I also own separate property? So a revocable trust, it all depends. Some clients are comfortable with creating one revocable trust that can hold both the community assets of both of the spouses and then the separate property. And we could just put different provisions about what should happen to these assets on death. But the trust can hold both separate and community property. Some clients are more comfortable in creating separate trusts. So for example, a married couple could have a joint trust that holds their community property, and each of the spouses could have separate revocable trusts that just hold their respective separate property asset. It really just depends on how you and your spouse are comfortable with holding the assets. So in terms of managing the assets during your lifetime, there's virtually no difference between holding the assets in your name as an individual versus holding the assets in your name as trustee of your own revocable trust. Now, the reason why we like to use revocable trusts is that they are a great vehicle for planning on incapacity. And the reason why we like using a revocable trust is that the alternative, meaning if you don't have a revocable trust and all we have are just assets in your individual name and you become incapacitated, typically what's required is actually a court-supervised proceeding. It's called a conservatorship proceeding, where the court appoints a conservator to manage your assets for your benefit during your incapacity. And as you can quite imagine, the court proceedings can be, one, expensive, two, once you're in court, you're actually subject to a lot of court rules, so the conservator has less flexibility than your trustee would otherwise have. And then three, I think everybody can pretty much imagine how stressful it is for the person who's just on the verge of losing capacity or is incapacitated to then be subject to a public court proceedings where their incapacity is discussed, there are rulings by the judge. So definitely it's quite more embarrassing for anybody to be subject to court-supervised conservatorship proceeding versus if you have a trust. It's not court-supervised. Once you become incapacitated, your successor trustee, who's a person that you've named in the document, steps in to manage the assets in the trust for your benefit. And I briefly touched on the role of the durable power of attorney in connection with managing assets during incapacity. So again, imagine that you're incapacitated and you're very thorough. Most of your assets are in the revocable trust, so the successor trustee steps in, can manage those assets for you during your incapacity. But there are always certain assets that for some reason we can't put in the trust, or maybe they were just forgotten. And a good example of that would be your retirement plan. And I mentioned that the revocable trust is essentially disregarded for most purposes. One of the major exceptions would be retirement plans. So your retirement plans, your IRAs, your 401ks, because they're income tax deferred, there's a quirky provision in the income tax laws that say that if you were to transfer your retirement plans to your revocable trust, it would automatically trigger all of the unpaid income tax. So for that purpose, we specifically don't transfer retirement plans to the revocable trust during your lifetime, but if you become incapacitated, the trustee wouldn't be able to act with respect of the retirement plan. So that's why we need an agent under the power of attorney to be able to do some of these things that the trustee can do. And ideally, I typically recommend to my clients to name the same person as a trustee for incapacity as the agent under your power of attorney. So then you just really have one person acting both as trustee or as agent who's able to manage the assets for you if you're incapacitated. So again, really a lot of benefits to creating a revocable trust when you're dealing with assets if you're incapacitated. Now, let's talk about the advantages of a revocable trust for management and disposition of assets on death. Again, very similar to what we talked about earlier. Once you pass away, remember we talked about during your lifetime, you have this very strong right to revoke the trust and change the terms. Once you pass away, the person with that right is gone and the trust becomes irrevocable. That means nobody can change the terms. The trust is its own legal entity and the trust holds title to all of your assets. So you as an individual, you've passed away and you actually have no assets to your own name. If you have no assets to your own name, we don't have to go to court to administer your estate. You just don't have an estate. Quite frankly, the main reason why attorneys prefer relying on revocable trusts for disposition of assets on death is just it keeps us away from the probate court. And again, in some states that's not the case, but in California, attorneys don't like to be in probate court because one, it tends sometimes to be more expensive. Two, again, your executor has less flexibility because the executor only has powers that the probate code gives them. The trustee has all of the powers that you build into the document. You can give your trustee fairly broad powers and a lot of flexibility. So the probate administrations tend to be much more difficult for your executor than a trust administration would be for your trustee. And then lastly, a lot of my clients really like the not being in court because of the ability to keep your affairs private. So if you pass away just with a will or without a document, and we have to go to probate to administer your estate, this matter is just a matter of public record. So anybody can go to court, look up your will, see what you've provided in your will. Anybody can check what your assets are. And in my experience, literally the day I file a probate petition for a client, the next day my client, the executor, will get hundreds of calls from realtors who had just read the court records and found out that there's real property, and they're all offering their services. So again, the revocable trust does give you a fair amount of privacy. The terms of the trust are not going to be public. The trust is not completely private. The people who are entitled to a copy of your revocable trust after you pass away are, one, the beneficiaries of your trust. So whoever you name in your documents, obviously these people can request to receive a copy from the trustee. And then the other group of people who can receive a copy of the trust would be your heirs at law. Your heirs at law are the people who would receive your assets if you passed away without any documents. So, if you essentially died intestate. And so the way that this works is, because again, if you have a revocable trust, we're not in court, so the court is not supervising what the trustee is doing. The law builds in this protection against fraud. So if somebody had come up with a fraudulent trust, and the trust, for example, disinherits your heirs at law, so the natural people who would receive your assets, these people could actually ask for a copy, so that if the law thinks that if there was any fraud going on, the heirs at law would then alert the court that the trust is fraudulent, and then bring the matter to the court supervision. So a good example is, for example, I am married and I have a son. I can disinherit them. The law allows me to disinherit my closest family. But if I did do that, my son and my husband would be able to ask for a copy of my revocable trust so that they could check that this is really what I wanted to do. So most of the time, trusts are very give you a lot of privacy. And again, typically the trustees don't go around offering copies of the trust to everybody. They just wait until they're asked. And quite frankly, oftentimes in situations where your heirs at law might not be natural spouse or children, maybe they're more distant relatives if you don't have children or are not married. A lot of times these people don't even ask for a copy of the trust. And again, we don't offer it, but if we're asked, you would have to provide a copy. Okay, so I just talked about how wonderful the revocable trust is for planning on death and for planning on incapacity. Now, the question that comes up is, what is it really going to cost me? How much more do I have to pay to create this trust during my lifetime? And in terms of legal costs involved, it is typically more expensive to create a revocable trust than just have a simple will. And the reason is the trust has to be a longer document because, again, I have to build in a lot of provisions to give the trustee flexibility. I have to analyze tax consequences and just make sure that it works. So trusts are longer documents. They're more complicated to draft than a will. Although again, the same dispositive provisions can be built in both into a trust or in a will, but it typically takes lawyers a little bit more time to create a revocable trust. And the revocable trust comes with actually a lot of work that you'll have to do during your lifetime. So if you just pass away with a will, there's nothing you have to do. You pass away, your executor then takes the will and then collects all the assets. If you create a revocable trust, great, you pay the attorney sets up the document, you sign it, but remember, the trust is empty until you actually put assets into it, and you have to transfer assets into it during your lifetime. With respect to real estate, it's not very complicated. Your estate planning attorney will typically also help you with preparation of deeds to transfer your real property. from your individual name to your name as trustee of your trust. So that's fairly straightforward. But you have to do some follow-up as well. If the real property is transferred, you might have to obtain endorsements on your title insurance policy, on your homeowner's insurance policy. If you have securities or brokerage accounts, you'll have to talk to your broker to retitle these accounts or these securities into your name as trustee of the trust. And again, there's paperwork involved. You have to prove that the trust exists. You have to sign some additional documents. If you have encumbered commercial property, the lender might require a fee after the property is transferred to the revocable trust. If you own interest in legal entities, for example, if you own interest in a partnership or in an LLC, your estate planning attorney will have to prepare assignments of the interest to the trust. The attorney will have to read the governing documents, so whether that's an operating agreement or partnership agreement. It might have restrictions on transfer that the assignment has to specifically address. You might have to obtain consent of other owners of the entity. So again, this doesn't mean that it's impossible. It's going to be a little bit of work for you to actually transfer the assets to the trust. Now, that's all great because all of the work that you can do now, that just means your successor trustee will have less work to do. So we definitely do emphasize that it's very important for you to complete all these steps so that you don't just pass away with an empty trust and then we have to use the will to add everything after your death. Now, in terms of going forward, you'll have a trust that you'll have to maintain. So if you acquire new assets, each time you buy something new, whether that's, again, stocks, securities, or maybe new property, you'll have to title it in your name as trustee of the trust. And again, typically in purchase agreements, you'll have to just provide additional documentation if you're not buying the asset in your individual name, if you're buying it as a trustee of your trust. And one caveat that I also wanted to mention that comes up quite a bit with real property is that if you plan on refinancing your real property that's held through your revocable trust, oftentimes the lender, they won't have an issue with doing the refinance itself. They'll just say, well, we don't like that it's held through your revocable trust. For the purposes of the refinancing, you have to take it out, and you have this power to do it, so you just take it out, and then they close the loan, and then you can put the property back in the trust. Now, in my experience, we've had a number of situations in our office where we have clients who come with almost completely funded trusts, and then we find this one piece of real property that's outside because during your refinance, the property was never placed back in trust. So you do have to be careful if lenders require that you take assets in and out, that you actually do put them back. And then, so we talked about the fact that we like the revocable trust because it avoids going to court. Sometimes, even if we never have to go to court to use the pour-over will, sometimes the trustee might still want to go to court after your death, and that's in the rare situations when your beneficiaries don't agree. So if you can imagine a situation where you pass away and your trust holds a white acre and black acre, and you have two beneficiaries, A and B, and both A and B want white acre, because the trustee is supposed to be impartial and can't take sides of one beneficiary over the other, the trustee might be worried that if the distribution is not equal, the trustee could be sued by one of the beneficiaries for breach of duty, fiduciary duty. So sometimes our trustees actually decide to go to court to get the court's blessing on some of these actions where the trustees are worried, well, if we're not in court, the court is not blessing what I'm doing, and I could be subject to maybe a lawsuit from one of the beneficiaries if the beneficiaries don't get along and don't agree. So from time to time, again, even if we have a revocable trust, we do go to court, but that's only in situations where, typically in situations where beneficiaries have a dispute. Okay, so I think this is just a basic setup of your estate plan. And let's talk a little bit more about estate and gift tax. The regime in the United States right now is such that each person can pass up to $5,450,000 of wealth without any estate tax. And what it means for married couples is that each spouse in the couple has this amount of exclusion from gift or estate tax to use. It's an amount that you can use during your lifetime or as a death. So for example, if you make a transfer of $1 million to your child during your life, you only have $4.5 million, or approximately $4.5 million left to use at death. So you can use some during your lifetime, and then you can use the remaining amount on death. And then if you have assets over that amount, so that's and I'm just going to approximate it over to say $5.5 million or $11 million for a married couple. And so if you have assets over that amount, there's an estate tax that's incurred at 40% for transfers above that exclusion amount. And the exclusion amount is indexed for inflation, so each year it might be adjusted for inflation. It'll go up a little bit, but as you can imagine with anything else, typically your assets will appreciate at a much higher rate than the inflation adjustment. And one of the main exceptions to the general rule that there's estate tax or gift tax on transfers above the exclusion is the marital deduction. So right now, you could pass an unlimited amount of wealth to your spouse without any estate or gift tax whatsoever, and that's assuming your spouse is a U.S. resident. And that's great. It really doesn't mean that that we're avoiding estate tax. We're just really deferring it. So, for example, if the first spouse passes away and the surviving spouse receives all of the assets, there's no estate tax on the first death, but obviously the government will collect the share when the second spouse passes away. And the marital deduction is really nice. And the way that it's worked in the past, and remember, each spouse has the approximately $5.5 million to use, was such that sometimes we ran into complications for couples who owned, roughly the amount of the exclusion. So let's just imagine that under the prior law, for a couple that owns jointly $11 million, let's say that the first spouse passes away, leaves the $5.5 million of that spouse's share of the assets to the surviving spouse. Well, great. Marital deduction, absolutely no estate tax, and then the surviving spouse has $11 million in his or her name. Oh, gee, when the surviving spouse passes away, the surviving spouse only has $5.5 million of exclusion of his or her own, so then the other $5.5 million would be subject to 40% tax, and that's because we never used the exclusion that was applicable to the first spouse to die because we relied on the marital deduction. So that was a really bad consequence, and for that purpose, attorneys would structure revocable trusts such that on the first death, we would create an irrevocable trust that holds assets equal to the amount of the exclusion that the first spouse to die had. So in my scenario, let's imagine that we just put $5.5 million in the separate trust. The surviving spouse would be the beneficiary of that trust and could use the assets for support. Wouldn't be able to use the assets to, let's say, go and gamble at a casino or give it away to whoever he or she wanted, but would be able to access it for support if he or she ran out of her own money, his or her own money. But again, an irrevocable trust established on the first death, the surviving spouse will have to file separate tax returns. It's an irrevocable trust where no one can change the terms. So it definitely took away quite a bit of flexibility that the surviving spouse would otherwise have. So to help with this problem, we've recently, the rules have changed so that the surviving spouse can actually save the unused exclusion from the deceased spouse. It's called portability. So what portability does is, in my scenario, if I have the same couple with $11 million, the first spouse to die could leave all of his or her own assets to the surviving spouse. The surviving spouse has to file an estate tax return to claim the unused exclusion. So again, there are definitely costs involved in preparing the estate tax return. And then the surviving spouse essentially has additional credit of whatever the deceased spouse did not use that can be applied on the surviving spouse's death. So then, rather than relying on putting the assets into an irrevocable trust, the assets could go outright to the surviving spouse, and the surviving spouse would just be able to save some of the unused exclusion. And it works sometimes. It definitely works for some couples, but you can probably also imagine what if the assets are such that they're very likely to appreciate. So in the same scenario that we had, what if the $5.5 million that the deceased spouse owned turn up to be $20 million when the surviving spouse dies? Well, then you have additional $50 million that's not going to be covered by any exclusion because the reported exclusion was just $5.5 million. So in that situation, oftentimes attorneys actually have to now think about, what might be better, because if we establish that separate trust on the first death, where we could apply the exclusion, that money in that trust will never be taxed again when the surviving spouse dies. So it's really nice. If we did that on the first death, we put in $5.5 million, it grows to be 20 on the surviving spouse's death. There's no additional estate tax that the surviving spouse pays. So for some clients, it just means attorneys have to think a little bit more when they're doing planning and analyze, is it better to just rely on the portability to make it more flexible for the surviving spouse, or maybe is it better for us tax-wise to still do the irrevocable trust on the first death because maybe we're worried about appreciation of assets. Okay, so we talked about the marital deduction, the estate tax exclusion, and then we've discussed portability. I also want to talk about another kind of transfer tax, which is called the generation skipping transfer tax. So that's a tax that's applied in addition to the gift or the estate tax if you make transfers to people who are essentially your grandchildren's generation. And if the person is not a family member, it would be someone who's 37.5 years younger than you are. So we sometimes joke, when we have clients who are unmarried and maybe have much younger partners, you really have to worry about the GST tax. The GST, there's an exemption from the GST tax that's equal to the exclusion from the estate tax. So that's also approximately $5.5 million. So you can shelter up to $5.5 million of worth that's transferred to your grandchildren, or to trusts that will ultimately benefit your grandchildren. So we do have to, and generation skipping transfer tax is incurred also at 40% after you've used your exemption. There is a little bit of free benefit that the government gives you, and that's called the annual exclusion from gift and estate tax. And the annual exclusion is also indexed for inflation. It's currently $14,000 a person. So a married couple could give up to $28,000 to as many people as you can possibly imagine, if you wanted to. And I joke, in my practice, I have a few clients where, because they have a lot of children, the children are married, and they have a lot of grandchildren, I have clients who can easily pass $500,000 each year without paying any estate tax at all. And the beauty of using the annual exclusion is such that not only you're removing value of assets from your own estate, so then it's not taxed when you pass away, but also you're not even using a single dollar from the $5.5 million exclusion. So it's really, for a lot of clients, if you start planning ahead of time, the annual exclusion is a really nice way of planning for estate tax. And if you're a little worried about, well, maybe I don't want to give $14,000 to my 2-year-old grandson, that's just, first of all, that's a minor, and then who knows how responsible the child is going to be. You don't have to give it outright. You could make the gift into a special trust where someone else will be the trustee. So in the grandchild situation, we could set up an irrevocable trust where you qualify still for the exclusion from transfer taxes, and someone else will be essentially in charge of these assets for the grandchild's benefit until a time you specify, and you'd be in control in terms of deciding, what the terms of the trust are, when the beneficiary gets to be able to have access to the assets. So it's really a nice, thing to use if you're worried about paying estate tax on that. In California, we don't have an inheritance tax. It was abolished in 1982. But keep in mind, if you own assets in other states might have inheritance tax. A lot of clients in California might have property in Oregon or Washington State. Those are states that still have the inheritance tax. So just keep in mind that if you have property in a state that still applies the state level inheritance or estate tax, you might still have to pay something to a state, even though you're not a resident of that state. It's just by virtue of owning assets in that state. And then what I also wanted to talk about is nowadays with the exclusion amounts from estate tax being so high, we have fewer and fewer people who are actually subject to estate tax. So what attorneys now actually plan for more is the income tax on assets that are going to be inherited. One of the wonderful provisions in the Internal Revenue Code is what's called a step-up in basis rule. So let's imagine that you purchased 1 share of Apple stock and it was worth $10. You paid $10 for it. And then the day before you pass away, that share of Apple stock is worth $1,000. If you sell it before you die, you paid $10 for it. That's your income tax basis. If you sold it for $1,000, there's $990 of gain, and you pay income tax, and that's the capital gains income tax on the gain. So that's something that you would have to do if you sold assets that are highly appreciated during your lifetime. Now, if that same share of Apple stock is given to your child through your revocable trust on death, we have a different rule. And the rule is such that when your child receives that same share of Apple stock that you paid $10 for, the income tax basis for that for your child's share is not $10, it's stepped up to the value of the asset on your death. So that's why it's called the step up in basis. We step up the basis on your death for any assets to the fair market value of that asset on your date of death. So then if your child gets the share of Apple stock through your revocable trust on death and turns around and sells it the next day, there's absolutely no income tax to be paid because the income tax basis was $1,000, sales price was $1,000, absolutely no income tax. So definitely something to keep in mind, if you have assets that are highly appreciated, and again, it's sort of a game between paying the estate tax or paying the income tax. But if you're not worried about estate tax, definitely better to hold on to highly appreciated assets and then pass them to your beneficiaries because they will get it with a stepped-up basis. Okay, so I can imagine a lot of the listeners today own properties, so let's not forget to talk about property tax implications. One of the really nice rules right now that we have in California is that if you transfer property to your child, and this could be a transfer, through your revocable trust on death, or it could be a gift during life, it could even be a sale to a child. If you transfer property to your child, you are able to exclude the property from being reassessed for property tax purposes. And the limitations are such that you could give or you can transfer property to your child if it's a primary residence. It doesn't matter how valuable it is. So you can transfer your primary residence, and then you can transfer up to $1 million of assessed value. It's not fair market value, it's assessed value. So if you have property that's highly appreciated, but the assessed value is still fairly low because of Prop 13, you could transfer up to $1 million of assessed value to children. And the way that the rule works, it actually works both ways, so your children could also pass property to you. There's a parallel rule for transfers to grandchildren. It's much more limited in scope. So if you're thinking about transferring real property to a grandchild, definitely talk to your estate planning attorney. That rule essentially only applies if your child has predeceased, and it doesn't work both ways. So your grandchild can transfer property to you. And then let's talk about transfers of interest in legal entities that hold real estate. So a lot of my clients own real estate through LLCs or limited partnerships, And you have to be really very careful if you then transfer your interest in those entities to individuals to make sure that you do not trigger a reassessment that you were not planning on. So let's just imagine a scenario where you and your brother own Winegrape, and that Winegrape is held through an LLC. So you own 50% of the LLC, and your brother owns 50% of the LLC, and the LLC owns 100% of Winegrape. And let's imagine then you decide, I want to make a gift of 25% of my share to my son, and your brother gives 30% of the brother's share to the brother's son. That transfer, because you've transferred more than 50% of the original owner's interest. The original owners were you and your brother, more than 50%, because we transferred 25% and 30%, is transferred to other people, would trigger reassessment of the entire property. So it's a really, harsh rule, and the parent-child exclusion does not apply. So if you did that same transfer, but you owned the property not through an LLC, you just owned it as tenants in common, you could apply the parent-child exclusion, but you can't apply it if the property is held through a legal entity. So you have to definitely be very careful when you're doing transfers of legal entities. Now, another rule that comes with entities that own real estate is if you have a person who acquires more than 50% control over the entity, then you also trigger automatic reassessment of the entire property. So you just have to be essentially very careful and make sure that you talk to an attorney before the transfers. Okay, so we've talked about lots of different tax regimes. Let's talk about maybe what we could do to help plan during your lifetime so that the taxes are reduced. And again, I touched on briefly on the annual exclusion gift. That's really an easy way of reducing your estate so that your estate is, you make a gift during lifetime, your estate will be lower when you pass away. There's going to be lower estate tax because obviously the value's already been removed during lifetime, and you do not use any of your lifetime exclusion from estate or gift tax. So the annual exclusion gifts, they're really a great way of planning for estate taxes. Now, another vehicle that clients like to use to help pay estate tax, if you have a taxable estate, and I have enough assets where on my death, my beneficiaries will have to pay estate tax. And let's imagine also that it's not just all cash. Maybe those are properties or maybe illiquid assets that you don't want your beneficiaries to have to sell. Well, how are you going to raise the cash to actually pay the estate tax? And one way that you could plan for it is to do a life insurance trust. A life insurance trust is an irrevocable trust that you establish during your lifetime. You establish this trust. No one can change the terms. It's a legal entity right from creation. And you make a gift to the trust. So that would be a gift that will count against your combined exclusion. Let's say you put cash into that trust. The trustee then turns around, uses the cash in the trust to buy a life insurance policy on your life. And again, you've made this gift during your lifetime. It's not part of your estate. The assets of the life insurance trust, if it's set up properly, will not be includable in your estate when you die, because you've made that gift during your lifetime. It's not coming back to add to your estate. When the policy pays out, the policy amount, again, is not added into your estate. It's owned by the trust because the trust owns the policy on your life. So there's immediate liquidity so that the beneficiaries of your estate, your taxable estate, would have cash to be able to pay the estate tax. So the life insurance trusts are really nice because one, if you do have a life insurance policy, you're removing that policy from your estate, and then also you're providing for liquidity to pay estate tax on your death. So we have the life insurance trust. And then the other thing I want to talk about just briefly are, there are some, we generally think of this as freezing techniques. So those are defective grantor trusts. Again, those are irrevocable trusts that you establish during your lifetime. And the reason why I'm calling them freezing techniques is if you are in a situation where you have a lot of assets that you think will highly appreciate by the time of your death, it might be worth to actually make a gift of these assets during your lifetime. So that, let's say, you have a property that's worth $1 million now, but you're worried it's going to be worth $20 million when you die. If you make a gift at current values, you're essentially freezing the value. You're making the gift when it's worth $1 million. You've only used $1 million of your combined exclusion. So it's really nice. You still have a lot left, and if the worry is that you wouldn't have enough to cover it when you're on your death, you can make a lifetime gift. And you could, again, clients often don't like to make gifts outright. We could put it in this special kind of a trust where you decide what the terms are, you decide how much access the beneficiaries will have, and we make it, the reason why we call it defective is even though the gift to the trust is effective for transfer taxes, for gift and estate tax purposes, it's not effective for income tax purposes. And sometimes paying the income tax is a really good thing. So imagine, let's say you have a security that pays a dividend, and you make a gift of that security into the defective grantor trust. So you make a gift, you pay the, and you use your exclusion from estate tax or gift tax on the transfer. The trust now owns the asset. However, the IRS still thinks that you own the asset for income tax purposes. So when the dividend is paid out, you individually, even though you don't own it the asset anymore, you still pay the income tax on it. So that just means that you're able to pass on more wealth to your beneficiaries because, one, you're reducing your own estate by paying income tax, and two, you're essentially passing the income tax for free that otherwise your beneficiaries would have to come up and pay. So that's a good planning technique. And then the last thing I want to talk about is maybe a little bit more unusual, but I thought in this group this might be something that you'd want to hear about, are the conservation easements. So a lot of my clients who are landowners are interested in conservation easements. Conservation easement is a restriction on your land. So essentially, let's imagine again, you have a piece of property that's worth $1 million. You place a conservation easement on it, and the conservation easement is a restriction that says nobody forever will be able to develop this land and put, a skyscraper on it. Well, the property is now worth less to potential buyers because you've removed this possibility of development from the land. And for a lot of my clients, it's attractive because they would not want to develop the land one way or the other anyways. So we put in this restriction on transfer. That means that your value of the asset is depreciated. Let's say the conservation easement now means that the land is only worth $700,000. Well, that's great because that means we pay less estate tax on your death. And in addition, for the conservation easements, the nice thing about them too is if you donate the conservation easement, so the right to enforce that restriction, if you donate the right to enforce that restriction to a public charity, and that could be your local land trust, you get an income tax deduction for the value of the gift. So in our situation, if we've donated a $300,000 reduction in value to a land trust, that's actually something that you can use on your income tax return to as an offset. And typically the way the laws for the conservation easements change every year, but you're typically able to carry it forward if you can't use the entire amount of the gift in the first year. Okay, we are on to 45 minutes, and I now want to pass it back to Mike.
Thank you, Agnieszka. How do we do that? There we go. Okay, I know that a lot of the people on the call are people who own quite a bit of land because that's kind of what you do with growing grapes. And the issue of liquidity in estates is really critical when you owned a lot of land and you want to pass it from generation to generation. So let's assume that you did all the things that Agnieszka talked about and you reduce the estate as much as you possibly can by setting up various kinds of trusts and all the things that she talked about. But your estate is still subject to some taxes and other costs. How do you actually deal with that? So the tax is due in cash within 9 months of the date of death, unless you do a certain technique that can extend that. but most estates want to settle as quickly as possible. So you now have a big tax bill that could be in the millions and tens of millions of dollars. So what do you do to get the cash to pay it? Well, one way is to borrow the money. Another way is just to write a check from the value of the estate, from liquid assets. You can sell securities, you can liquidate real estate or other assets, or you can use the proceeds of life insurance. So let's talk about the advantages and disadvantages of each of those ways to come up with the cash. If you borrow the money, you have to pay back the loan as well as all of the interest that you have to pay for the loan. And in many estates, if you pay it over like a 10-year period, you can pay back twice as much as what the original bill is. So that may not be the best way to do it. Also, there can be problems getting loans because banks are more difficult to deal with today, even with people with large estates. The next way to pay it is just to write a check with cash, but then you're giving up 100% dollars, and you really have no earning power on the money that you use to pay the taxes to the government. The next way is to sell securities, and if you do that, if the market is up, you're okay. If the market is down, it can be a very expensive way to do it. So timing is very important here, and you can't control the timing. Another thing that you can do is to liquidate real estate or other assets, but if your business is growing grapes, you don't want to give away the assets that are producing the revenue for you and your family. And timing is another issue with real estate. The market for real estate can be good or it can be not so good. The other alternative is to use life insurance so that you're really buying dollars for future delivery that only cost pennies a piece. So the payment is prompt because as soon as you notify the insurance company, they write a check. If the policy ownership is structured properly, there is no income or estate tax on the proceeds, and the premium payments can be spread out over your lifetime rather than paid all at once as you would if you were paying the taxes in cash. And generally, insurance policies are not subject to probate. So let's talk about a special deal that, and this is very hypothetical, that your bank could offer to deal with the IRS. Let's say, and think about this in the terms that your banker comes to you and says, I will set up a special escrow account for you. The bank will put away $1 million in cash, and even though the current loan interest rates for unsecured loans is 7%, we'll only charge you 2 or 3% per year, and it will be an interest-only loan. So you don't have to amortize the $1 million that we have in escrow for you. But the deal is that at the death of the second spouse, the bank will pay $1 million to the IRS for your estate taxes. And unlike a traditional loan, you won't have to pay back the $1 million. All you will have paid is the 2 or 3% per year while you were alive. Now, the answer to this is that banks will not do this sort of thing, but life insurance companies will. So if you have any interest in finding a way to provide liquidity and you're insurable, this could be the best way to deal with estate settlement costs. That's our formal program. So we have some questions that have been written in, and if you'd like to ask more questions, the lines are open for that. So just jot your questions down and we'd be delighted to provide answers. So the first question is, can you read that, Agnieszka, or maybe Natalie can?
The first question is from Susan. She says, we live on our property and grow and make the wine at the property. She's in the process of developing a living trust to include our home and land in it, but their winery is an LLC to protect us until we get the living trust in place. How can we incorporate an LLC into a living trust?
That's a very, very good question. So maybe one of the things that I need to mention is the living trust provides you with absolutely no creditor protection, because again, the living trust means that gives you this power to change terms as many times as you want. So if you put property into the living trust, you don't have any of the same protections as holding assets through an LLC. Now, for a lot of my clients, the LLC itself could be an asset of your revocable trust. So once you're actually in the process, after you set up your revocable trust, once it's set up, the funding of the LLC into the trust will be part of the work that you'll have to do. So this is something that I briefly mentioned. When you have the LLC, just make sure that you mention it to your estate planning attorney. Your estate planning attorney will take a look at the operating agreement, make sure that you're complying with all of the restrictions on transfer, and then prepare an assignment of your interest in the LLC to the revocable trust. So the LLC is no different than any other asset that you have. It's just, make sure that you do the step of funding it into the revocable trust. So it's you do the two things together. The LLC is an asset that will become part of your trust after the trust is set up.
Perfect. We hope that answered your question, Susan. Do we have any more questions? Okay, if not, thank you so much for joining us today. I will email out the complete webinar today along with additional handouts. So thank you for joining us.